That, my Lord, would be completely
Just hold on, Mr. Just hold on.
The next 96 hours or so will be critical for Chief Justice David Maraga and his 5 colleagues at the Apex Court as they determine the fate of 2 presidential election petitions filed by John Harun Mwau, Helef Halifa and Jonjo Mue. The judges proceed on a 3-day retreat, during which they will caucus on the issues that were prosecuted by legal teams representing the petitioners and the respondents in the 3rd round of presidential election petitions filed at the Supreme Court.
We will deliver judgment on the 20th. The exact time you will be informed by the registrar.
Just like in the August presidential petition, the 6 judges will distill the issues that came up during the oral submissions and backed up by the written submissions and prepare one ruling if they are in consensus on the verdict. Alternatively, each judge can file his or her verdict with the majority carrying the day.
Thank you, Mr. Gato.
Among the issues for determination by the country's top judges is what constitutes a fresh presidential election and whether IEBC should have conducted fresh nominations for presidential candidates contesting in the repeat State House contest. The petitioners argued that IEBC should have organized fresh nominations, a position negated by the Commission, President Uhuru Kenyatta, the Attorney General, and Dr. Ekuru Aukot was joined as an interested party.
It is not in doubt that the first and second respondents and the 3rd respondent knew about the importance of nomination. And to demonstrate that, I'll direct you to the Gazette Notice number 8751. Under that section, the first and second respondents say that they are exercising powers under Section 14, which requires nomination day to be set, under Article 137, which requires candidate to qualify for nominations, under Section 22 and 23, which all require nominations. They knew when they were writing that the nominations are necessary. They closed their eyes. They turned their backs.
The judges will also have to determine if NASA leader Raila Odinga's withdrawal from the race, 16 days to the ballot, should have triggered a cancellation of the October 26th exercise and a fresh date picked.
Now, to my mind, I know there is a controversy of, can you only be deemed to withdraw if you use this procedure? My answer is yes. Where the law, and these courts have said that over and over and over again, where the law provides a procedure, that procedure must be complied with.
That the repeat presidential election was not conducted in 25 constituencies in Kisumu, Homa Bay, Migori and Siaya counties is yet another key issue for determination by the Supreme Court bench. Article 138 sub-article 2 of the Constitution requires that a presidential poll be held in each of the constituencies.
When we say it is possible to hold elections in some parts of the country and disregard the right of 25 constituencies to hold an election, we are sowing the seeds of anarchy and disunity.
6 judges heard the petition, with Justice Mohammed Ibrahim still away on medical grounds. The 6 Supreme Court judges have less than 4 days to distill hours of submissions and thousands of documents submitted to them by the petitioners and respondents' legal teams and determine if Kenyans will return to the ballot for the 3rd time in under 6 months, or President Uhuru Kenyatta and his deputy William Ruto will be sworn into office to serve for a 2nd term on the 28th of this month. Francis Gachuri, Citizen TV at the Supreme Court, Nairobi.